Members of the jury, the evidence in this case has been completed. In a moment, I will read to you the law which you must apply in order to reach your verdict. But first, I want to mention a few things that you need to keep in mind when you are discussing the case in the jury room. It is my job to decide what rules of law apply to the case. While the lawyers may have commented during the trial on some of these rules, you are to be guided by what I say about them. You must follow all the rules as I explain them to you. Even if you disagree or don't understand the reasons for some of the rules, you must follow them. No single rule describes all the law which must be applied. Therefore, the rules must be considered together as a whole. During the course of the trial, you received all of the evidence that you may properly consider to decide the case. Your decision must be made by applying the rules of law which I give you to the evidence presented in the trial. Neither sympathy nor prejudice should influence your decision. If you decide that the prosecution has proved beyond a reasonable doubt that Brenda Pudum Walker has committed the crime as charged, it will be my job to decide what the punishment will be. It should not enter into your consideration at any time. At the time during the trial when the lawyers made objections to questions asked by other lawyers and to answers by witnesses, do not draw any conclusions from such objections or from the rulings or from my rulings on those objections. These only related to the legal questions that I had to determine and should not influence your thinking. When I told you not to consider a particular statement, you were told to put that statement out of your mind, and you may not consider any statement in your deliberations which you were instructed to disregard. Sometimes in the trial, I have asked questions of witnesses. When I've asked questions, that did not indicate that I had an opinion about the facts in the case. Finally, you should consider all of the evidence in light of your observations and experiences in life. The charge against the defendant is the prosecutor's claim that the defendant committed a crime. The charge is not evidence that the defendant committed any crime and are merely accusations. In this case, the charge is murder in the second degree. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless you are considering all of the evidence. You are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to satisfaction of the jury beyond a reasonable doubt that the existence of the elements of the necessary to constitute a crime exist. Reasonable doubt means a doubt based upon reason and common sense, which arises from fair and rational consideration of all the evidence, or lack of evidence, in the case. It is a doubt which is not vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you should find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty. The evidence from which you are to decide the facts consists of the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness, the exhibits that have been admitted into evidence, any facts that the court judicially noticed, and any stipulations of the parties. In reaching your verdict, you should consider all of the testimony and exhibits admitted into evidence. Certain things are not evidence, and you may not consider them in deciding what the facts are. These include arguments and statements by the lawyers. The lawyers are not witnesses. What they have said in their closing arguments is intended to help you interpret the evidence, but is not evidence itself. If the facts as you remember them differ in the ways from which the lawyers have stated them, your memory of them controls. It is not proper for the attorneys to express their opinions on the ultimate issues in the case or to appeal to your emotions. Testimony that has been excluded or stricken. The documents called the information, which you will have at the time of your deliberation, The information is merely the formal manner of accusing a person of a crime in order to bring him or her to trial. You must not consider the information as evidence of guilt of the defendant or draw any inferences of guilt because she has been charged with a crime. There are, generally speaking, two kinds of evidence, direct and circumstantial. Direct evidence is testimony by a witness about what the witness personally saw or heard or did. Circumstantial evidence is indirect evidence. That is, evidence from which you could find that other facts exist, even though it has not been directly proven. There's no legal distinction between direct and circumstantial evidence as far as probative value. The law permits you to give equal weight to both, but it is for you to decide how much weight you give to any particular evidence. Circumstantial evidence of any event is the testimony of a witness as to the existence of certain facts or evidence, or the happening of other evidence from which you may logically conclude that an event in question did happen. For example, let us assume that it's a December night and you're preparing to go to sleep for the evening. You look out the window and you see that it's snowing. You wake up the next morning, come to court, and testify that the night before it was snowing near your house. That is direct evidence of the fact that it snowed the night before because you saw it, you came into court, and you testified to that fact. Now assume that it's another December night. The weather is clear, there's no snow on the ground, and you go to sleep for the evening. You wake up the next morning, you look out the window, and you see snow on the ground and footprints across your lawn. You come to court and you testify to those facts. The evidence that the night before there was no snow on the ground, and the next morning that there was snow on the ground and footprints across your lawn is direct evidence. That direct evidence, however, is circumstantial evidence of the fact that at some time during the night it snowed, and that sometime thereafter someone walked across your lawn. The only practical difference between direct and circumstantial evidence is that when you have direct evidence of some fact, the main thing you have to do is to determine the believability of the direct testimony given, the credibility of the witnesses. With circumstantial evidence, you must first determine the credibility of the witnesses or witnessed, and then decide whether or not the facts testified to existed. Then you must decide the happenings of those events or the existence of those facts logically lead to the conclusion that the other events occurred or the other facts existed, and ultimately whether the crime alleged was committed by the accused. There's no reason to be prejudiced against the evidence simply because it is circumstantial. You may make decisions on the basis of circumstantial evidence in the everyday affairs of life. There's no reason why decisions based on circumstantial evidence should not be made in the courtroom. In fact, proof by circumstantial evidence may be as conclusive as would be the testimony of a witness speaking on the basis of their own observation. Circumstantial evidence, therefore, is offered to prove a certain fact from which you are asked to infer the existence of other sets of facts. Before you decide that a fact has been proved by circumstantial evidence, you must consider all the evidence in light of the reason, experience, and common sense. The mere number of witnesses testifying for or against a certain point does not necessarily prove or disprove that point. In deciding what testimony to believe, you should carefully consider all the testimony given and the circumstances under which each witness has testified. Consider each witness's knowledge, motive, state of mind, demeanor, and manner while on the stand. Consider the witness's means of knowledge, ability to observe, and strength of memory. Consider also any relationship each witness may have to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. You should consider all the facts, circumstances that are shown by evidence, which affects the credibility of the witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. You have heard witnesses who have testified today as experts. You are not bound by the testimony of the experts. This testimony is to be weighed as that of any other witness. It is entirely your decision to determine what weight shall be given to the testimony. The defendant does not have to testify. The decision not to testify is not evidence, does not prove anything, and should not be considered for any purpose. Members of the jury may discuss this case only when you are all present, and you all may only deliberate in the jury room. No juror should attempt to discuss the case with other jurors or anyone else at any other time except when all 12 of you are in the jury room. Once you begin your deliberations, if you have a question, your foreperson should write it down on a piece of paper, sign it, give it to the bailiff, and then the bailiff will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that under the law the court is not permitted to answer. Please don't speculate about what the answer to your question might have been or why the court is unable to answer that particular question. The bailiff will now escort you to the jury room. Upon reaching the jury room, you are to select one of your members as the foreperson of the jury. Your foreperson will preside over your deliberations and shall sign whatever verdict you reach. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree to it. Your verdict must be unanimous. Only one verdict shall be returned and signed, and the unsigned verdicts and these instructions shall remain the possession of your foreperson until such time as they are called for in open court. Upon reaching a verdict, you will inform the bailiff of the court, who will in turn notify the court, and then you will remain in the jury room until called into the courtroom. You will be provided with 4 forms of verdict. When you have unanimously agreed upon your verdict, you will select the form which reflects your verdict, and the foreperson will sign it as the court has stated. The unsigned form shall be returned with no markings on them. The forms of the verdict you will receive are as follows. The first will say guilty of second-degree murder. The second will say guilty of voluntary manslaughter. The third will say guilty of involuntary manslaughter. And the fourth will say not guilty. You are further instructed that no inferences are to be drawn from the order in which the court has read those verdicts. You are now dismissed to the jury room to begin deliberations.